Can your employer access your social media account? That's the question I'll be addressing in today's video. And like most questions that involve the law, the answer will depend on a few different things. So stick around to the end of this video to find out more. Nothing in this video is legal advice, but if you live in Washington State and you want to hire an employment attorney, feel free to reach out to my firm. The link to my website is in the description below. Before we talk about what the law prohibits, let's first address what the law allows. It's very common to research people on social media. When you meet someone new, you might go on their social media account to find out more about that person. Well, that same thing is true for employers. When an employer interviews an applicant, the employer may research the applicant by looking at their public social media profile. And there's nothing wrong with doing that. If you choose to make your profile public and you post content on that public profile, anyone is free to look at it. And employers are even permitted to make employment decisions based on what they see. The bottom line is that if your profile is public, it's fair game. So be careful about what you post on public profiles because it might come back to haunt you. But what if your profile is private? Or what if your employer asks for your login details to access your social media account? Well, that's where it can get a little tricky. As of making this video in 2022, there are no federal laws that specifically address social media privacy. Federal laws are those laws that apply to everyone, no matter which state you're located in. So there's no umbrella rule that applies to everyone, at least not yet. But states are free to make their own laws. And so far in 2022, according to the National Conference of State Legislatures, there are 27 states that have laws that protect social media privacy. I'll put a list of those states on the screen now, and I'll link to the NCSL's website in the description below because more states will be added to that list in the future, I'm sure of it. So how do these laws work? Let's get into that. The state laws that protect social media privacy are pretty similar from state to state. But since I'm licensed in Washington, I'll be going over Washington's social media privacy law. And you can find this law in the Revised Code of Washington, section 49.44.200. And I'll put that law on the screen now. The law states that an employer may not require an employee or applicant to access their account in the employer's presence, to change their privacy settings of the account, to include the employer in a list of approved contacts, or to disclose login information. Additionally, the employer is prohibited under this law from taking an adverse action against the employee who refuses to do any of the above. So, let's break that down a little bit more to see exactly what conduct is prohibited by this law. So the law that I just detailed prohibits 5 different activities that are all illegal. So let's go over each of them. First, login information. An employer cannot ask you for your login information to your social media accounts. Second, shoulder surfing. An employer cannot ask you to access your social media account while it looks over your shoulder. Third, adding to a list of approved contacts. An employer can't require you to add them to an approved list of contacts like a friends list that would allow them to view your private content. And fourth, privacy settings. An employer can't request or require you to change your privacy settings to allow them or a third party to view your private content. And finally, adverse action. If they ask you to do any of the things that we just discussed and you refuse to do it, the employer cannot take an adverse action against you, like refusing to give you a job or firing you from a job that you already have. So, now that we know what is prohibited by social media privacy laws, we have to talk about the exceptions to those laws. There are always exceptions. And Washington's social media privacy law has 2 big exceptions: investigations and work-related networks. First, the law does not apply to legitimate investigations, but the investigation has to be legitimate. If the employer just wants to snoop on your social media, and in order to do so, it says that it's going to investigate something, that's probably not permitted. But if the employer requests content to make a factual determination in response to a report about your social media activity, and the purpose of that investigation is to comply with the law, then that's probably a legitimate investigation, and the employer is allowed to do that. But even in a legitimate investigation, the employer cannot ever request your login information. It can only request content. The second exception is for work-related networks. If the employer uses a social network for workers to communicate and collaborate with each other for work-related purposes, well, that's not protected by this law. So for instance, if your employer requires you to communicate with coworkers via Slack, those communications are probably not protected by this law because it's a work-related network. So be careful about what you say on Slack or other similar networks. So what do you get if your employer violates this law and you sue them in court? Well, if you win your claim, you can collect the actual damages, a penalty of $500, and your attorney's fees and costs. Actual damages include your lost wages and emotional harms. Lost wages are the wages you would have received had you kept your job. So if your employer fired you for refusing to share your private social media content, or firing you for what it found on your private social media content, you could collect the wages from the time you were fired. And emotional distress damages is compensation for the emotional harm your employer subjected you to, like the humiliation from having to disclose private information. And attorney's fees are the fees that your attorney accrued from prosecuting your claim. These fees can be substantial because taking a case through the litigation process can take an attorney hundreds of hours. And hourly rates for attorneys are pretty high. So there you go. While not all states have social media privacy laws, the majority of states do. And the states that do have social media privacy laws prohibit employers from requesting or requiring workers to disclose login information or otherwise enable the employer to access their private social media content. And if you think your employer has illegally requested private social media information from you, feel free to contact my firm. The link to my website is in the description below. And if you like this video, make sure to share it with other workers. The more we hold employers accountable for their wrongdoing, the more we protect other workers. That's all for me this week. See you next time.